Mr. Sacco, good morning.
Good morning, Madam Chief Justice. May it please the Court, Michael Sacco here on behalf of the Beverly Retirement Board. The issue before the Court today is whether or not the definition of regular compensation...
They want to wait.
Oh, I'm sorry. If I may. The issue before the Court this morning is whether the definition of regular compensation shall be expanded as such that an employer may ascribe a value to a vehicle, a government-owned vehicle.
Just a procedural matter, did you or anybody object to the procedure in this case that before the administrative procedure was exhausted, the plaintiff rushed into Superior Court?
We did, Your Honor, and we had filed a motion to dismiss the matter in Superior Court for failure to exhaust administrative remedies.
But didn't Dallas say that it wasn't going to hear it for years? I mean,
Yes,
months and months and months?
yes. What happened procedurally was that there were 3 other matters that came before the adjudicatory authority, the Contributory Retirement Appeal Board. In those 3 cases, CRAB determined that the personal use value of vehicle was not regular compensation. There were dozens of appeals pending before CRAB. Since CRAB had ruled as a matter of law that it was not regular compensation, they sent a notice to all the other petitioners stating that they would not hear the cases until the matter had run its natural course through the court system, through Chapter 30A and beyond, and hopefully that would resolve the matter. What Mr. Pelonzi did upon receiving that notice was circumvent the process and go into Superior Court, which the judge said that he had the right to do that simply because he had no other avenue to pursue at that time. So we did object to that, but that was dismissed. And so then it then came before the court on a very limited set of facts. There was
Could I ask you one question about those facts, though?
Of course.
I think you are the only one, but correct me if I'm wrong, who says in his brief, or her brief, that Mr. Pelonzi did not pay income tax on the value of this automobile. Is that in the record?
It's not in the record, Your Honor.
One way or the other, or?
No, there is nothing in the record to which addresses that issue.
But he paid, but retirement deductions were taken out on the value
There's
of the car.
no information about whether or not it was part of what he paid income tax on?
No, there was no information to that. Again, this was part of the problem, and to Justice Cowan's point, so I don't lose that, retirement deductions were not withheld.
I thought one brief said they were.
What happened, well, if I may, what happened, Mr. Pelonzi signed his contract in 1997. When he went to retire in September of 2002, and again, forgive me, this is not in the record, but I have the copy of the check with me, he did not pay for the use of the car until March of 2002.
You mean he didn't pay for the deductions for the use of the car?
Correct. The deductions were not submitted to the Retirement Board until March of 2002.
After he retired or before he retired?
About 6 months before he retired, Your Honor.
So 6 months before he retired, he tendered a check to make up for the deductions.
That's correct. That's correct.
Is that question dispositive? I mean, could people pay taxes on parking spaces and a lot of other things? The IRS will attribute a certain benefit to them, a taxable benefit. Does that necessarily always result in the throwing in that figure into their retirement?
I don't think it is dispositive one way or the other, Your Honor. As you correctly point out, there are certain payments that are considered to be taxable income, for example, bonuses and overtime are taxable income, but yet excluded from regular compensation. So,
But the difference is bonus or overtime isn't regular. I mean, this seems to be a combination of regular, and the question I'm having is it compensation? So that's where the tax information would be very helpful.
well, I can represent, and I believe Mr. Collins will agree that Mr. Pelonzi did not pay income tax on this because of an exclusion that exists in the Internal Revenue Code regarding public safety officials who have personal use of a vehicle. They're not required to claim that because it's non-taxable fringe benefit income, which I would respectfully suggest takes it out of the regular compensation aspect.
But we have a definition of compensation, and it doesn't say we just go by the Internal Revenue Code.
That's correct. We don't, Your Honor. But if you, of all the items which are identified as regular compensation, both in the statutory and the regulatory framework, all of them are taxable income, whether it's longevity or educational incentive, whether it's your wages, the night differential, such as in the Bauer case. All of those are taxable items. But I agree that the definition, and if we move to that,
So the exemption under the Internal Revenue Code of a certain value for income tax purposes doesn't necessarily determine the question either. The fact that he did not pay taxes on it doesn't mean that it is not regular income for retirement purposes. It's just a policy determination made by the Internal Revenue Service or by Congress.
I have to concede that point, Your Honor, that is true, although I've never known the IRS to not seek its pound of flesh from any kind of income.
They want police officers to have a car 24 hours a day so that they can respond in an emergency.
Well, again, Your Honor, if perhaps that was the intent, again, because we don't have any underlying facts in terms of responding to an emergency, but I'll get to that.
But it strikes me that the bottom line is if you provide, in this case, a public safety officer with a car so that they can do their job, that really seems to be not a form of compensation, but really, in essence, the tools to do the job. I'm provided with a computer so I can do my job. I'm provided with I'm not, but I'd like to be provided with a BlackBerry so I can do my job. That doesn't become then my regular compensation, even though the service provisions and the repair and everything is paid. But if, in fact, the car is provided to you, not to do your job, but as a part of your overall package of compensation, I hate to use that word, but in truth, many people are given cars, complete free use of a car as part of a compensation package. Where does this fall?
Well, Your Honor, I think in terms of when you look at a compensation package, as you mentioned the computer, if you were given a laptop computer and allowed to use it for your own personal use at home, and that laptop computer is worth $3,000, does that mean you're not going to be paying taxes on it?
If you can use it for your personal use, but I
Yes.
think that's a big distinction here. This car was both for his professional and his personal use.
Correct.
So that makes it compensation because he got personal use out of it. And if you got a computer and you're just supposed to use it at home for professional use, that's one thing. If you get a computer and it specifically says for professional and personal use, you're getting some value. You don't have to buy a computer at home.
There is value to it. There's no doubt about that, Your Honor. But there's also a value to the health benefits that are provided to employees that they don't have to pay for. Should that also be included as regular compensation? I would suggest to you that they should not. That there must be a fundamental distinction between a benefit of employment, which I believe that the car is a benefit of employment.
But we're taxed on the money that is used to buy our health insurance.
We're not taxed on the portion that the employer pays. If you pay 20% and the employer pays 80%, you're getting a value of that.
The IRS will figure it out.
Well, you get a value in that 80%, and again,
So do we look to the purpose for which the item was given to the employee? A police car was given to a police officer is essentially as a tool of the trade, as a tool of the occupation, something that's necessary to carry out the occupation. Does that mean that's the criteria that we should use to decide that it's not to be calculated for retirement purposes?
well, I think arguably, Your Honor, you could say that the use of the vehicle, both professional and personal, it's all professional, because if someone has a vehicle that they can use it when they're off duty to go to the store for whatever reason, the moment that they have to respond to an emergency, and I would suggest to you, Your Honors, that when an emergency strikes in the police or fire, the officers responding or the firefighters are not waiting at the scene to get direction from the chief. They're going in, they're doing the job. There are very few, and again, because the record was not developed, there are very few circumstances in which the response to an emergency is a necessity to administer either a police action or fire suppression. 30 seconds can mean the difference between saving a life and a total involving of a fire in a home or in a building. So when you look at the car, it's virtually all professional use, and if they can use it for personal reasons, which clearly he
It's a
can.
benefit to the job and not remuneration. is what you're
Exactly, Your Honor. And it is a wonderful benefit because none of
But,
these
but this man,
individuals...
but this man bargained for this instead
Well,
of
we don't
additional
know that he
compensation.
bargained for it, Your Honor. Again, that's been suggested in the briefs, and I will admit that in all of our briefs, we have assumed facts that are not in evidence.
But even if he did bargain for it, I take it that in response to the bargain, maybe the city said, gee, that's a great idea. You know, if the police officer is at the drugstore, you know, getting some Band-Aids or something like that, and there's word of a bank robbery a half a mile away, we don't want this officer going home first to get the cruiser. We want this, or him or her, to get in the cruiser right there at the drugstore and go right to the bank robbery.
That may be true, Your Honor, but let's think of it in another context. If it's a bargainable item, how integral is it to have personal use of the vehicle? If the suggestion, which Perrak has advanced, that, well, he would have asked for more salary.
Well, firefighters bargain for certain time shifts that they contend are more efficient for the administration of firefighting.
Sure, in the context of a collective bargaining, but we're generally talking about one individual. And if the vehicle is so important that you have to have it to respond to emergencies, yet you could make a bargain to say, well, I'll take an extra $15,000 and I won't use the vehicle. Doesn't that defeat the whole argument that it's integral to the job? I think we have
This
to...
means the police officers had a better idea than the people they were negotiating with.
Well, that very well could...
That can happen.
That could be. That very well could be, Your Honor. But this notion that it has always been regular compensation since the statute was enacted in 1945, it's amazing to me that it took until 2001 for a memoranda first to be issued by the Oversight Authority saying it is regular compensation and always has been. And then there were successive memos, each correcting what had said in a prior memorandum. But I think fundamental to the issue, Your Honor, is do we want to expand that definition of regular compensation? And when the court
Mr.
said...
Sacco, your time is
I'm
up.
sorry. Thank you very much.
Thank you, Mr. Sacco. Mr. Ogwin?
Good morning, Your Honors. May it please the Court. James Arguin, Assistant Attorney General, on behalf of the Contributory Retirement Appeal Board.
I don't understand your argument. Could you please explain it to me? You say over and over that the only regular compensation specifically identified by the legislature is the boarding and housing allowance in 32, Section 22(1)(c). But that's defined in that, it seems to me, in that section, just so the payroll people know what to deduct for payroll. How does that connect with the definition of regular compensation in 32, Section 1? It doesn't say it connects.
It does connect
Yeah, but how
specifically
do you say it does?
32 Section 1 defines regular compensation.
Right.
And the first clause identifies the general definition. The second clause includes several exceptions from the definition of regular compensation, including bonus, overtime, and severance pay. The third clause then contains some exceptions to the exceptions that pulls back into the definition of regular compensation, things such as the non-cash boarding and housing maintenance allowance that's specifically provided for in Section 22, 1C. And I would also point, when you flip to 22, Section 1C, you find that it provides very specific directions to the distributing officer for how they should treat this particular form of non-cash benefit by adding it to the amount of the cash compensation that's paid to an employee. And I think the specific directions, both for how they use that particular benefit in terms of calculating regular compensation and the deductions for contributions that are regularly made, is indicative of a legislative intent to exclude other forms of non-cash contributions, non-cash compensation.
You live by the sword, you die by the sword. The statute first says not including, and then specifically lists what's not included. This is not in that list.
Exactly.
This is
Not
in that
including not including certain specified types of payments, which
Right.
include the bonus, severance pay, and
Unused sick leave.
overtime and sick leave. The other ones, obviously the statute has been amended over time, and it's included
Unused sick
several
leave-
different.
Excuse me,
I'm sorry.
Mr. Ogwin. Unused sick leave typically or frequently is paid out in cash when you leave, correct?
Certainly as a lump sum, so
Yeah,
it may
so
not
it's-
meet the regular definition.
No, I understand that. So that by excluding that, again, you're focused on a cash that may come to the employee, and the legislature saying bonus, sick leave, because you often get paid out for that, and use vacation time. They're saying that's not compensation.
That's correct.
Yeah.
Isn't the simple answer to this case that this is as has been alluded to, just a giving of an employee a something that's necessary for him to do his job?
I think it is exactly, Your Honor, and that's our other argument.
I mean, otherwise this could go down in all different directions. I mean, if you give police officers uniforms, that could become part of their compensation. I mean, we could have all kinds of claims here.
I think it would open up the retirement system to a whole bunch of anticipated and open-ended burdens, and that's why Crabb's articulation of the distinction that the legislature has drawn in the definition of regular compensation between non-cash and cash makes sense, because it helps define it. And the second part is, of course, as Your Honor's pointing out, the distinction here between what's personal and professional service really is not helpful, because a fire chief who's on call 24 hours a day, 7 days a week, always has to be available in the event of an emergency. But to make sure that the plaintiff could respond in the case of an emergency, the city supplied him a car. And it's just like any other tool or piece of equipment that a city provides to fulfill the purposes of the job.
That is helpful in this case. I prefer to stick to the cash and non-cash for this reason. There may be lots of reasons why an employee negotiates for a non-cash, which may or may not be closely professionally related, for all kinds of reasons that may be personal to the employee. What you do is you may get some upside on your taxable income or something like that, but you're going to lose it on your pension. In other words, there's a fair consistency, and so what you really can't do is to have employees negotiating for non-cash benefits that they then later claim are the basis for a pension.
I think that's absolutely right. And the Contributory Retirement Appeals Board is not attempting to limit the ability of an employee to negotiate with their employing unit here at the city. All we're asking is that they do so in a way that would lend some predictability and surety to the calculation of retirement benefits.
So
and
what does this mean? Compensation in whatever form means cash. That's what you're saying? Cash. So in whatever form, read that out.
No, what I'm suggesting is you don't read it out, but that you read it in context of the words that are also used in Section 1, which surrounds it by salary, wages, which this court has also said that the phrase other compensation, whatever kind, must be read in connection with that to indicate all the ways that employees are paid for the services they provide to their employer, which is confirmed by the following clause in the definition, which says that it must be lawfully determined for the individual service of the employee.
I couldn't agree with you more, but what is to say that the providing of an employee with a car for their personal benefit can't be just that? Other form of compensation provided for the individual service of the employee.
Well,
the director of an authority, the senior management of an authority in Massachusetts. Part of their compensation package is a car, full maintenance, a salary, a home maintenance allowance. I mean, why are those different?
I think they're different because, at least in the context of this case, what's being provided is a car so that he could carry out the 24/7 nature of his employment. If here, for instance, instead of giving him actual physical use of the car, they just gave him a stipend to cover the cost of the car, and they paid for that. They paid that stipend on a regular basis.
Yeah, but
it's still a stipend. I'm sorry, Your Honor.
No, go ahead.
It's still a stipend that's not paid or geared toward the services he's providing. It's paying him for a piece of equipment that he can use to carry out the employer's job. What I suggested is if they really, truly want to accomplish the aim of enhancing a compensation package, what the statute anticipates and what the surety that the retirement system requires is that they negotiate that. They be upfront in dealing with it. If they want it to be a piece of compensation, then pay him for it. Fold it into the payment for the services, the salary, wages, and other cash compensation that they've negotiated. But what they shouldn't do is create these artifices that open up the retirement system to this kind of unknown risk of increased burdens that no one can logically anticipate.
And my question to you is, who's opened that up? Is it the language of the statute which has opened it up?
I don't believe so, because I think the reasonable interpretation that Crabb has given to the statute makes a distinction. The legislature was very specific in providing for one form of non-cash one form of non-cash compensation, and it provided specific mechanisms in 22(1)(z) for how to deal with it.
So you're not suggesting that somehow this is the way we should always interpret the word including, meaning only what follows and nothing else.
No, I'm not suggesting that at
Because
all.
this word is used an awful lot.
It is used an awful lot, and I think in the right context that a different interpretation would apply. But here, where everything is geared toward cash compensation, and Section 22(1)(c) makes that clear as well, because it talks about adding the non-cash value of the housing and rooming allowance to the amount of the cash compensation. In every other form of compensation that this court has ever interpreted under Chapter 32, it's been payment geared toward services, either, special pay for doing special extra services or something that was in the form of a bonus or other. This opens the door to a whole host of other things that my brother pointed out, including parking spaces, health insurance,
Computers.
life insurance benefits, and even retirement benefits themselves could be folded into the definition and increase exponentially the burden on the state retirement system. And for that reason, the judgment of the Superior Court should be reversed. In this case, should be remanded to the Superior Court for entry of a declaration that the personal use value of an employer-supplied car is not regular compensation.
Thank you, Mr. Ogren. Mr. Collins?
Madam Chief Justice, good morning, everyone. I'm here, I think, with only 6 minutes to speak, partly because of my history with the case. I was actually involved when the IRS made the regulation back in 85 or 86, exempting the police and fire from the tax consequences. It drafted the statute in Massachusetts that allowed Massachusetts police chiefs and fire chiefs to negotiate their employment contracts. And the reason you don't have amicus briefs from either side is because much of my time is spent either representing the Police Chiefs Association or the Fire Chiefs Association, so I'm here. And much of my time for the last probably 10 years has been negotiating contracts on behalf of police chiefs and fire chiefs. So I think many of the questions, the practical ones here that you've been asking, would be things that I might be able to address, and I'll try to anticipate some of those and leave some of the more precise legal questions to my sister, if that's all right. And quite frankly, what happened was in this situation, you can read, we had a person who was a fire chief, and he was doing his job as a fire chief. The city came to him and said, by the way, would you mind taking on these other departments? We'd like not to hire a new police chief and a new person in charge of the harbor masters and things like that. We'd like you to take all that, and we'll call you a public safety commissioner, and we'll give you some money in exchange for that. And as you saw, and it's a very public record, the MMA publishes all this, typically when that happens, people get about $20,000 increase in pay. His contract said I'll get $10,000 increase in cash, and I'll get the personal use of a motor vehicle provided by the
And
city.
there may have been good reasons why he wanted that.
Right.
It may have affected his, income tax. It may have affected. I'm not going to hypothesize. It may have affected what he was using cash for and other purposes. He may have had. I'm not suggesting he did, but he may have had alimony determined on that. All kinds of reasons why people don't want cash. But CLAB and the citizens of Massachusetts have to figure out what are going to be the retirement benefits. Actuarially, we have to determine them. And it seems to me that the legislature has made it pretty clear. It's money, and the reason why you have salary, as Mr. Ogren suggested, sometimes you get bonuses, and sometimes you get overtime, and sometimes you get, but it's cash. And then occasionally the legislature, for whatever reason, has specified, housing being the most obvious one.
Agreed, Your Honor. Quite frankly, the situation here, when I first was involved with PERAC, and as you saw, there were 3 different memos, their initial reaction was the same. As it turns out, as you know, if I hire a person in my law firm and say, I'm going to give you $75,000 in cash and a car that's worth something, and the IRS does tax it for most people. The fact is, right now, there's a very definitive way for figuring out what value there is on a personal use value when I give you a motor vehicle.
And I understand that.
So
but
what
that's
happens is,
because the Internal Revenue Service has wanted to tax the citizens, but that doesn't mean to say what the legislature decided should be part of your pension.
and each year for the past several years, as you probably know, the legislature has put a bill in trying to say we will take out the issue of motor vehicle, and most recently the chairman of the Senate Ways and Means Committee, and they get defeated. So I'm not implying you can read a lot into that, but the legislature has been trying to amend the statute, the definition, recently to say, why don't we take the automobile out of there? Okay, and it's been defeated each time. So I would suggest to you that at least some people think that the automobile, quite frankly, as a result maybe of this case and the PERAC's definitions and so on, ought to be part of all that. It saves the city and town lots of money. What happens is when we negotiate these, and we've done, honestly, scores of them, nobody gets hired as a police chief and a fire chief nowadays without an employment contract. The city is looking to save some money. So they say, we know we're going to supply a vehicle anyways. Why don't we try to save some money? Rather than pay them $10,000 extra, we will essentially give them an automobile. It doesn't cost the city or town really any extra money. Okay? It is a real benefit to the person. It's part of their compensation package, and the city's saving a lot of money. This all came to be because back in the early 90s, before the law got passed where you could negotiate a contract, the city and towns were laying off people, and they were starting for the first time to say, let's see what we can do to find some ways to compensate you that don't cost us a lot of money. We're back in that position right now. No, quite frankly, it's not. I'm just talking right now generally the things people would be aware of, that there was a massive layoff.
I understand that, I think the hypotheticals are whether it's because it benefits the town, whether it's because it benefits the individual, whether it benefits all kinds of people. It seems to me that we're looking at the statute, and how you yes, maybe you think there's an easy way to calculate it because the Internal Revenue Service will calculate what the personal use of a BlackBerry is or isn't. That's a different issue, it seems to me. It's really the statute and how we've interpreted the statute to date.
And the problem is, and obviously the problem, and it just jumps off the page, how can compensation in whatever form mean cash? Right?
That
makes no
exactly our
sense.
point. Yeah. And so it's very easily defined on all the people who apply for this nowadays, and they've been doing it for years. As you probably know, many of the retirement boards are granting this. Other
Doesn't
people
that
are holding their
create
breath.
a very slippery slope?
No.
We go to parking,
No.
we go to computers, why not?
Well, for example, in this particular case here, all those other things there are the IRS for scores of years has defined exactly how you calculate what the value is, the personal use value of an automobile is. There has been no precedent whatsoever for the computers and the laptops and the
No parking.
Parking there has
We
been.
pay tax on our parking space.
Agreed. Okay.
So then parking might be a retirement benefit.
I'm not saying it's impossible. Okay.
It's a slippery slope. We go to the next thing and the
Why-
next
why-
thing. and the
But
next thing.
remember that the system's not being burdened at all. When they're paying right now, if you're going to hire me at 75 or with a car, and I pay my 5, 10, 12% toward that, the system is not being burdened, because if you're going to give me $3,000 more per year, I'm going to pay my 5% on top of that. If you don't give it to me in cash, but you give it to me as an automobile, I'm going to still pay 5% of that into the system. So the system is not burdened. There is no extra burden. They've done an actuarial study that they'll tell you about. There's no burden, quite frankly, on the system once everybody starts paying into it for this, whether the city or town put some money in your pocket or they give you the automobile. The income to PARAC and the outgo from PARAC will be identical. There is no burden in the system at all.
Would you agree with me that if the item is provided, whether it's a computer or a car, for purposes of doing your job, then that really isn't compensation?
That's correct. And this is not provided for the purpose of doing your job. It's negotiated because otherwise I or my wife will have to get a car. So we negotiate and we say, great, I'm going to give you the personal use. There are whole different IRS regulations. If I can only use the car for many chiefs can only take the car home and respond to emergencies.
I understand.
And so this particular one negotiated something different. I now have the personal use value, which means it does have an equivalent value. We know exactly what it is, and there's no dispute about that. The people at PARAC have made up regulations, so everyone knows exactly how to calculate it. We know how to pay our percentage into the retirement system. It's very neutral in terms of revenue or expenses. So when you do all that, it's very different. This is not for the benefit. If it were just for the benefit of the city or town, then there is no personal use benefit. No one would be here.
Thank you, Mr. Collins.
Thank you all.
Ms. Colligan?
Good morning. I'm Judith Corrigan, and I'm the Deputy General Counsel at the Public Employee Retirement Administration Commission, or PARAC. And with me here and on the brief is Barbara Phillips, PARAC's General Counsel. PARAC respectfully requests that the decision of the trial judge be affirmed. First, the monetary value of the personal use of an employer-supplied automobile is compensation to Mr. Pelonzi and others situated. This compensation has been lawfully determined for the individual service of Mr. Pelonzi by the City of Beverly, satisfying the Section 1's threshold definition of regular compensation. And the regular compensation is in keeping with this court's decision in the basis case. It's regular, recurring, ordinary. It will not place an untoward, massive, or continuing burden on the retirement systems. As Mr. Collins just mentioned, if you're paying deductions on a benefit throughout your career, at the end of your career, particularly people who are in Group 1 retirement, will be paying for their entire retirement allowance. So there will not be a burden on the system.
Let me ask you a couple of questions about that, though. I mean, here we're talking about an exempt vehicle. Right.
Exempt for federal purposes, Justice.
Oh, okay. So still, even though this is an exempt vehicle for federal tax purposes, it wouldn't be exempt for purposes of making a contribution to the retirement system.
Correct. When this whole thing began with PERAC issuing its first memo, the first question we received was about a federal tax question, and that's what we answered. But we're not bound by the IRS labeling of vehicles or labeling of other instrumentalities.
Understood. But now, as I understand, you also have a memorandum out there saying that people who have not gotten the benefit of this, in other words, this was not calculated into their retirement pay, and also didn't pay, they get the benefit, notwithstanding the fact that this was never implemented and never the way the statute had been interpreted.
You're
prior to
talking about the
2001.
fourth memo in the record, yes. And that is because when this issue came up, there were a group of retirees who had value of their car. And at that time, the tax counsel employed by PERAC, or used by PERAC, had said that before that retirees could make contributions into the system following their retirement. After this, in which I think it was memo number 38, 2002, which is at page 23 in the record, the special tax counsel said, no, retirees cannot make contributions to the retirement system. So in order to get the benefit, the retirees had to be given it without making contributions so as to avoid problems with the tax law. Will that be a problem going forward? It will not. If a chief has a car today, they're making a contribution on the car every day of their career. So it's not really going to be an untoward burden on the retirement system. It's unfortunate that that group of retirees falls into that category, but I don't think it's very many people.
How large a group, do you know?
I don't know, Justice.
Mr. Flanagan, excuse me, what about parking places?
Madam Chief Justice, you have framed the issue, I believe. Does our retirement system permit non-cash regular compensation other than the housing allowance? I believe parking spaces would be regular compensation under this analysis as presented in the PERAC brief. If your receipt...
So that, to take a hypothetical, with this building, it's got very few parking places. So, you know, it turns out that only 5 justices, or associate justices, who all have the same compensation set by the legislature, have access to parking in this building. The others don't. It's a seniority system.
Yes.
So their retirement benefits are greater? I mean, if that were the system?
Well, that's the way all employees are different. I mean, different employees get different benefits. But
It wasn't negotiated. It wasn't a contract. The legislature hasn't signed off on it. Very valuable. Really valuable.
IRS taxes it.
IRS taxes it. We don't pay any attention to how the IRS treats it.
Well, it depends upon whether you want to treat the parking space as... under PERAC's analysis, the parking space would be regular compensation.
I
Because it's a
understand that.
value,
And on
yes.
what conceivable basis is that an interpretation that the legislature has authorized? The legislature doesn't set the number of parking places. The legislature doesn't tell me whether I should leave 4 parking places for the superintendent of the building who's in here all of the time.
But the legislature did say compensation in whatever form. That's what the legislature said.
Yeah, but the
And
question is it compensation? It's not benefit in whatever form. It's not benefit in whatever form. It is compensation in whatever form.
It's a value to the employee, and it is lawfully determined for the individual service of the employee by the employer. Then it's compensation. It's regular compensation under our statute. Now, this is the exact, almost opposite of the Bulger case, the William Bulger case.
That's housing.
Yes, because the statute specifically allows housing, but the statute specifically allows a lot of things that are not listed. I mean, the statute, regular compensation doesn't consist only of what's listed in the definition of Section 1. In Bulger, he was getting a housing allowance where the statute provides for a non-cash housing allowance.
It was a cash allowance, is my point.
Correct.
It
And
was
then this
payment.
court said that he could get it because even though the statute provided for a non-cash, he could get it because he was receiving it in cash. So if Pelonzi was receiving $10,000 a year marked car allowance, under Bulger, he would receive that benefit
That's
as a
cash.
regular compensation.
That's
So
cash.
the issue becomes whether the contributory retirement system in Massachusetts excludes non-cash payments to employees. And I guess that's the issue before you. Otherwise, it fits the definition of regular compensation. We're not talking about his use of the car on duty.
Let me ask you this, Ms. Colligan, if I can. You have a group of retirees who didn't, for whatever reason, claim, and it wasn't deducted, and PERAC is now attempting to incorporate them, correct?
Yes.
Okay. So now we have just a lot of things out there. Stick to the technology ones. BlackBerry, cell phones, computers, pages, and a state employer has determined it doesn't make any sense to prohibit employees from using it for reasonable personal use. Telephones, that's a decision of each state employer. And then 10 years later, a group of people come in saying, gosh, we were allowed to use our BlackBerries and so on for personal use, and so that now should be considered part of our compensation.
Again,
Isn't that this case?
it really isn't, because the cars, the personal value of a car is
Personal value of a
discernible.
BlackBerry is expensive. Believe me. Do you
I
have a
don't, I don't have any personal knowledge about the
Well,
BlackBerry.
let me tell you, it's expensive.
Well, there's a whole category that the IRS, again, under guidance, uses
But
as
we're not
de
governed.
minimis benefits.
De minimis?
De minimis
It's
benefits.
not de minimis. You want to see the monthly statement on a BlackBerry?
I have no idea what the BlackBerry
It's
costs.
not de minimis. It's not de minimis.
Well, it would depend upon what the employer wanted you to use it for. Is it personal use of a BlackBerry?
No, it's part to do the business, partly business.
Is there any monetary value? In other words, if I use the employer's cell phone and it doesn't change the bill, there'll
it
be no
does.
value.
Oh, it does.
If we
I'm
don't
sorry,
ag-
I'm not more well-versed in BlackBerries.
If we don't agree with you, are there any consequences to people whose retirements have already been calculated on the basis of their having had a car, for instance?
I believe that there will be consequences.
Be
Is there
recompute it,
anything?
won't
Is there
they?
anything in the record that tells us how many people are having their retirement calculated at the moment?
There is nothing in the
Wouldn't you
record.
have to recompute their retirements?
The people who went out with a car, yes.
Yeah.
And repay, and
As in this
presumably
case.
repay their contributions.
As in this case, Mr. Pelonzi is, well, he's being paid right now, but it would be a value to him of about $327 a month.
Did I can't remember this, did the Beverly Retirement Board, when they changed, because it was first there and then, did they get it back? What, I don't mean now, I mean in the past, before he went to court. In other words, was there
I think the
a
court,
recouping of money, or just that going forward he wasn't going to be paid it?
I think they paid him for the first 2 months of his allowance, and then I'm not sure if he was required, and then they stopped paying him.
Right. I
And
just-
then they had to pay him back under the trial judge's order with
You
interest.
don't know if there was a recoupment order for the other, the 2 months he paid before that.
I'm not sure, I'm sorry.
Thank you, Ms. Corrigan.